Welcome back to SQE1 Window, you legal scholars. And today we are talking about privity of contract, one of those rules that sounds old-fashioned, but it is. And yet it is still managed to cause modern headaches, like, load of headaches under privity of contract, and you will be examined in it as well. Another headache. But hope you understand, and the headache is gone. The rule is simple. Only the parties to a contract can sue or be sued on it. That's it. If you did not sign up, you cannot cash in. And in Dunlop case, Dunlop sold tires through intermediaries who promised not to undercut prices. So when Selfridge broke the deal, Dunlop tried to sue, but the court said no, Dunlop was not a party to that contract. So if you're not a party to contract, no privity, no rights. Seems harsh, isn't it? But the logic is neat, clear. You must give value, provide consideration to gain rights. Think of it as the law's version of no membership, no privilege. Say, to understand the problem it created, we imagine how this creates different issues in real world, like, transactions. Suppose you order a new laptop as a gift for your friend and it arrives faulty. You cannot sue the supplier on your friend's behalf, and your friend cannot sue because they were not a party to the contract. Everyone loses, except, of course, the supplier. That wins. Or think of life insurance. The insured person dies and the benefit is meant for their spouse. Under the old rule, the spouse had no right to claim because they were not part of the contract. Rather unromantic, even by legal standards. So the courts started inventing or creating workarounds. And eventually Parliament said, enough, let's fix this properly. But before that, let's look at patches the judges used in common law to solve this issue. So, courts developed several exceptions to escape the fairness of strict privity. First, it was agency. So, if an agent makes a contract on behalf of a principal, the principal, though not named in the contract, can enforce it. Think of your solicitor signing on your behalf. You do not have to personally pick up the pen every time. Second, collateral contracts. The secondary promise can exist alongside the main one. So in Shanklin Pierce versus Detail Products, paint supplier told Pier owner that paint would last 7 years with an assurance. It peeled within months. The court found a collateral contract between the supplier and Pier owners, even though the purchase was made through the contractor. So the third thing that we need to understand is trust of contractual rights. One party may hold benefits under a contract on trust for someone else. This was recognized in, I can't pronounce it, I would say Walford case in 1919. And fourth is assignment. A party can assign rights under a contract to another as long as proper notice is given. And finally, covenant over land. Those are special promises that stick to the land itself. So the next owner inherits both the benefit and the burden. Property law's way of saying you bought it, you bought the problem too. Both of these things, benefit and problem, will follow the property. So there are statutory reforms to just consolidate all those things which were kind of developed by common law in 1999 Act. By the late 20th century, the courts were tired of legal gymnastics. Enter the Contract Right of Third Parties Act 1999. So at that point, once it was enacted, the parliamentary equivalent of deep sigh of relief for all those issues of privity of contract was offered to public. So under Section 1, a third party may enforce a term if the contract expressly provides that they can. The term purports to confer a benefit on them unless the contract clearly says otherwise. So the third party must be identified by name, class, or description, even if they do not yet exist when the contract is made. So in your exam, if you see this contract is made for the benefit of all future tenants, the future tenants might have enforceable rights. Not bad for people who have not even moved in yet. Good for them. So what are the limits under 1999 Act? Of course, the law never gives with one hand without taking with the other. Laws are always smart to bring justice to society. The Act allows the original parties to exclude third-party rights entirely by saying so explicitly in their contract. Many commercial contracts do exactly that. Look out for a clause titled third-party rights. You're reading a contract, so look at third-party rights and it will make everything clear for you. Once a third party's right have crystallized, meaning they have accepted the benefit or relied on it, the original parties cannot change or cancel the contract without their consent, meaning operation has already started. And if the promisor had any defenses against the original contracting party, those same defenses apply against the third party as well under Section 3 of the Act. So the Act modernizes privity but keeps it fair and also consolidates it. No new right without the risk that comes with it. So at that point, this law has ironed out everything for all of us. So there are key case examples. So let's see the Act in action. Certain cases were decided. It was Nation Shipping versus Gleeds in 2004. A broker arranged charting contracts that promised him a commission. So the contract said nothing about his enforcement rights, but he was clearly meant to benefit. The court held that the 1999 Act allowed him to enforce the clause. Contrast to this case law, we got Colwell case law in 2006 when the claim failed because the third party was not specifically identified. So this word, keep in mind, specifically identified in the contract. Moral of the story, someone is not enough. The law likes names. So then we got Clydesdale Bank case 2019. Investor who were unnamed in a letter of instruction could still enforce it because they were identifiable as a class of investors. So once it is identifiable, the court can be generous, but only when the description is clear, certain at that point. So identification is everything. The clearer the contract, the safer the right of third parties under it. So interaction with consideration. So now let's where privity and consideration shake hands awkwardly at some point. Consideration says only those who give something can sue or can use rights. Privity says only those who are party to contract can sue. Usually that's the same person, but not always. So under the 1999 Act, so it breaks the old link. A third party can now enforce a benefit without giving consideration. So yes, finally someone gets something for nothing, but only because Parliament said so. So in your SQE exam, always ask a question, who gave consideration? Who is the party or a party in it? If the answer is not the same person, check the 1999 Act or an exception at that point. If it is, go for otherwise normal or standard rule of consideration will apply. So commercial and practical impact of all of it in modern commerce, third party rights are everywhere. Subcontractors, insurers, beneficiaries, and financiers often depend on deals made between other parties, like, referrals online I've seen. So there are third parties which will take certain commission in it. In 1999 Act, this commercial reality came into being. But lawyers, being cautious creatures, often include a clause saying, no person other than the parties shall have any right under this contract. So at that point, you can save yourself. So if you ever read a contract and spot that line, do not panic. It's not hostility, it's a habit. Businesses prefer certainty, even if it means keeping the 1999 Act politely outside, so you can exclude it. This is private law and beauty of private law, that you can exclude certain parts of law as well. So, with the exam tips and pitfalls, the first one is start with the general rule. Only parties can sue. Quote Dunlop case, like, you need to keep in mind that's a general rule. Next step, move to exceptions: agency, collateral contracts, trust assignment, and land covenants, which are already developed by common law. Then the third thing is discuss statutory reforms under Section 1 of 1999 Act. So that's what you need to keep in mind. The fourth thing is check if the third party is clearly identified or not. So if it is identifiable or identified, of course, they will get the benefit under the Act. So common pitfalls are forgetting that parties can exclude the Act entirely. Yes, they can. So keep in mind. Mixing up consideration and privity, assuming benefit automatically gives rights. It is not without clear identification. Keep in mind, and ignoring the Act's limit on variation and offences. So, having said that, I hope you are clear on privity of contract. It's a bit difficult to understand in the beginning. If you don't understand it in first go, just go through our discussion again, and I bet you will get it. So thank you very much for being with us today, and see you with the next topic, that is terms of contract we will be talking about. So, ta-da!